Let's get back to it. And hello to those online as well. I'm sorry that we're running a little bit late here. There's obviously a lot to talk about in the margins, but thank you all of you for your patience. So this afternoon, we're turning in this session, as you can see, to look at specific litigation venue and strategies, and in particular to focus on the European Court of Human Rights and well, it says here the EU Charter, but of course the related court. And we've already talked quite a bit today. In the last session, we had, I think, we heard a lot of really rich interventions about the national level experience and the challenges, but we've also touched, of course, on the regional and international proceedings as well. And I think we've heard, I think foreshadowing to, this afternoon's discussion, we've heard some really positive comments about the innovative approach, about how, you know, some of what's happened at the Court of Justice of the European Community, I'm very tired, you can tell, right? European courts, the two European courts have actually been quite innovative and far-reaching, maybe went further than some of us expected on some things like interim measures. We've also heard about the impact in the Polish context, but we've also heard some quite important harsh criticism of the content of decisions as well as their lack of implementation. So we're going to dig a little bit deeper now in terms of those regional mechanisms, and we have two speakers to trigger our discussion. Online, first of all, we have Sanja Jovicic. I hope I'm pronouncing that right, Sanja. Thank you for being here and for being with us. So Sanja is project manager at the Fundamental Rights Agency. I'm afraid I don't have a bio beyond that for you, Sanja, but hopefully that's enough. Thank you very much for being here. And I'm going to hand over to you to make some introductory remarks.
Thank you. Good afternoon. Thanks for inviting me. As it was said, I work as a project manager at the EU Agency for Fundamental Rights. Before I worked for the Academy of European Law, ERA, the Court of Justice of the European Union, at the European Court of Human Rights, and also in the Slovenian justice system. And I was asked here to speak about international litigation venues, tools, and mechanisms to protect judicial independence. I will also speak about the EU Charter tools, which were developed by FRA. Although I'm representing the FRA, the opinions are my own, so don't cite FRA for whatever I will be saying today. So shall we kick off with the presentation, or would you like to say a few more words?
Yes, please. Yes, please go ahead. Thanks, Sanja.
All right. So what I will be speaking today is basically 3 points: how to bring the EU Charter into play, its relationship with the European Convention of Human Rights, and the Charter and the rule of law litigation. So first, this is just an overview table presenting you the different sections of the charters. As you see, there are 8 titles and different human rights. So you would find both civil and political rights, and economic and social rights, and some rights which are specific to the European Union, for example, the right to vote and stand for as candidate to the European Parliament elections, access to documents, and so forth. Just very briefly, when you apply the Charter, you should be aware that actually there's a distinction between rights and principles. So not all of the provisions of the Charter are rights, meaning that they can be invoked by individuals in court proceedings. So you would have to either check the explanations to the Charter. This is an annex attached to this legal document, and also or the Court of Justice case law, where the court would have said what provisions are rights and what are principles. And similarly to the European Convention of Human Rights, you have limitation clause in Article 52, paragraph 1. I leave it to you to read it in more detail later. So how to navigate the Charter? Just some practical tools that we have developed, the Charterpedia, for example. Let me just show you how this is used. So this is basically a search tool developed by the agency, which allows you to search by charter article. Let's find, for example, Article 47, the right to an effective remedy and to a fair trial. So you would get here the text of the article, the explanations, the case law. You can select the deciding body, the Court of Justice of the European Union, the European Court of Human Rights, or national courts. You can also find national constitutional law referring to the charter, relevant EU law, international law, if there is one, and also relevant FRA products in respect of this article. Next, you can also download an app where you can easily access the charter articles on your phone if necessary. And another important point for you to remember is Article 51 of the Charter. So as opposed to the European Convention of Human Rights, which applies in all situations, the Charter has a specific scope of application. So it always applies to the EU institutions and bodies, but to EU member states only when they're implementing union law. So he would have to fall within the scope of union law when you apply the Charter. This would mean that you would never apply the Charter on its own. You always have to find a new law provision together to be applicable with it. But this actually is not applicable to the rule of law cases. There, the court has said that you don't have to go into analysis of the Article 51 when you claim a violation of the rule of law. More on it a little bit later. So here is just a short overview. When would you be within the scope of the EU Charter? For example, when the member state acts as a EU agent, it adopts national legislation transposing, for example, a directive, when it acts within an authorization of EU law, when it uses its national remedies, sanctions for enforcement of EU law rights. Here are some examples of EU law implementation and some criteria taken from the case law of the Court of Justice, how to determine whether a national measure involves EU law implementation. This is a very useful tool, the Charter Handbook that was developed by FRA. It's based on the Court of Justice case law. It's very short and concise. It gives you a checklist for the applicability of the Charter, where you can basically check whether the Charter would be applicable in your case. Another interesting tool is the case law database, which basically feeds from the data of the Charterpedia, but it allows you to search the case law by additional tabs, for example, the European ECtHR article, by deciding body, by country, and by keyword search. So we have already updated the case law database with the national case law and the Court of Justice case law from 2022 last year, and how it would look like. So when you click on the case, you would find the title, the key facts of the case, the outcome of the case, and the paragraphs referring to the Charter, also in the original language. Another interesting tool for the trainers. So we have compiled a booklet with 8 practical case studies, again, based on the Court of Justice case law. You would get some factual scenarios, the national law, and questions for participants. In the end, the trainers would also get some background information on how to solve the case, how to answer the different questions. So far, they are available in Czech, Dutch, English, German, Hungarian, Italian, Polish, Romanian, and Spanish. But by the end of this year, they will be available in all EU languages. We also have an e-learning platform, so far available in German, English, and Spanish, but this one too will be available in all EU languages. A few words about the relationship between the Charter and the European Convention of Human Rights. Here is another table showing you how the Charter adds value to the ECtHR. For example, in light blue, you would see the rights which have an equivalent protection to the ECtHR. In yellow, there is no equivalent protection, right. For example, the right to asylum. And in dark blue, you have EU context-specific rights, as I said before. For example, the right to good administration. Red shows more extensive protection than the ECtHR. For example, data protection. Speaking about the Charter's substantive law added value, although it's a relatively young international law instrument, it does have some advantages compared to the European Convention of Human Rights. As I said, there are additional rights, economic and social rights. Some existing rights have a wider scope. For example, Article 47 on the right to a fair trial is wider in scope than Article 6 because it does not apply only to civil rights and obligations or a criminal charge, but also to other kinds of proceedings, for example, tax proceedings. And Article 52, paragraph 3 of the Charter specifies what is the relationship within the Charter and the ECtHR. So when the Charter contains rights which correspond to the rights guaranteed by the ECtHR, the meaning and scope of those rights shall be the same. So in that case, the ECtHR case law would be the minimum standard here. But if they don't correspond, then the Court of Justice would adopt actually its own interpretation. For example, Article 8 of the Charter on data protection, the court has said that it actually does not correspond to Article 8 of the ECtHR. And we have also a provision in the Treaty of the European Union, Article 6, which states that the Union shall accede to the European Convention, maybe making our life easier when applying the Charter and the ECtHR, but this is still to be seen what is going to happen in this regard. Some important points concerning the added value, substantive law added value of the Charter. We will have to consider that the EU legal order is very specific. You have the primacy of EU law, which would mean that EU law would prevail over national law in case of a conflict. You have direct effect, meaning that the EU law may create rights and duties directly for individual parties. If a provision doesn't have a direct effect, it would have indirect effect, which means that the national courts would have to interpret and apply national law in conformity with EU law. And breaches of EU law can lead also to state liability in line with the Frankovich case law. Also, when you apply the Charter, there is a very strong EU enforcement mechanism done either through the member states, courts, tribunals, competition authorities also, or by the European Commission. For example, the Commission has direct enforcement powers in competition cases, and it can start infringement proceedings. There is also access to the Court of Justice of the European Union via preliminary ruling proceedings and direct actions. I mean, being a lawyer, maybe it might be easier for you to access the Court of Justice. It has a little bit less pending cases than the European Court of Human Rights. Preliminary ruling proceedings can be initiated actually during the proceedings, so you don't have to wait. You don't have to exhaust domestic remedies before applying to the court, but you would have to argue actually your case that this is an EU law issue. I was asked also to present the ECtHR admissibility criteria, just as a few words. So be aware that there are some formalities to complete the application form. Make sure that it's really completed in full, that you provide the relevant data. You also have to fulfill the procedural requirements, so prove that the applicant had a victim status, that it has exhausted domestic remedies. This would mean normal remedies. So what would you normally have to do to exhaust the remedies? So extraordinary remedies, discretionary remedies would not have to be exhausted. Now the time limit now it's 4 months since you receive the decision of the last instance. The court would not accept anonymous applications, so the applicant has to provide a name. The court will not look into a matter which was substantially the same as a matter which was previously examined or which has already been submitted to another international procedure, for example, the Court of Justice or a UN treaty body procedure. And you can also become an abusive applicant at some point if you lodge several unsubstantiated, vexatious applications to the court. You have to also bear in mind that your application must come within the jurisdiction of the court. So the application must be addressed against a state party to the convention. You cannot complain against China or the United States. Your complaint must fall within the scope of the convention. So it means that there must be a right which is guaranteed by the convention. As I said before, Article 6 does not apply, for example, to tax proceedings. So you would really have to show that there is a civil right claim, a criminal charge for the court to examine your application. The jurisdiction of the court is usually, so it's territorial. So whatever happens in the state parties actually would fall within the court jurisdiction, but of course there are also exceptions in case of extraterritorial actions of the state. Also, your complaint must have happened, actually the facts of the case must have happened after the state party has become actually a party to the convention, but there are also exceptions to this matter in case of continuous violation. The facts have happened just shortly before the state became a party and then continued after. I would really suggest to check the practical guide on admissibility criteria where you can find actually the details of all kinds of admissibility criteria that the court would look into. And finally, also the court would not look into applications which are manifestly ill-founded, which concern a fourth instance matter. So when the applicant asks the court to ask as a fourth instance, so as a constitutional court, and nullify the domestic court decision. So this is not the role of the European Court. And also there's a new admissibility criteria. It's the non-significant disadvantage. The court would not look into matters which are minor importance. For example, you complain about the €5 bus ticket. This will certainly not be examined by the court. Here I put some links for your information where you can find the necessary documents for how to apply to the court. And very useful tool, ECtHR, which was recently developed by FRA together with the Council of Europe and the United Nations. So this is the kind of a Google search engine where you can search the commitments of EU member state plus the 3 candidate observer countries to FRA. Let me just show you how this would look like. So here you can search by convention. For example, I will put the Council of Europe Treaty by country. Let's put Austria. And then you would get this kind of like a table where you could see, if you click here, you would see which treaties the state has accepted. And when you click on the treaty, you get directly to the website of the Council of Europe. Another tab is compliance, where you could also check the documents of the relevant international monitoring mechanism. Here we have the court, the European Court of Human Rights, the European Committee of Social Rights, and different actually special bodies of the Council of Europe, the United Nations treaty bodies. And we are planning to add also the Court of Justice and the Venice Commission documents. Let me show you how this would look like. So let me choose Greta, country. Let's choose Belgium and then search. And you would see here another graph. And if you click on one of the documents, you get directly to the report of Greta concerning Belgium. I think yes, I put Belgium. And I don't know if you're already aware, but we are developing a help course together with the Council of Europe on the ECtHR and the Charter interplay. This will be launched in September this year. Here is an overview of the FRA tools on the Charter. And my last point will be the Charter and the rule of law litigation. So I will not speak about the factual situation in each case of the Court of Justice. I will just give you some general information on how the court would look into this matter. So for you, it's important to know that the court would always use Article 19, paragraph 1 of the Treaty of the European Union, Article 47 of the Charter, and some general principles which are there actually since the 60s, effective judicial protection, mutual trust, sincere cooperation, primacy of EU law, and conform interpretation of EU law. Here is the text of the provision. So as we see, Article 19, paragraph 1 actually establishes the jurisdiction of the Court of Justice for interpreting EU law together with actually national courts, and Article 47 gives the right to a remedy and to a fair trial. And the court has stated that both of these provisions have direct effect, which because they are clear and precise and unconditional. So this would mean that the national court can cite them in the operative part of their national decisions. So the court would say, I find a breach of Article 47 of the Charter not national law provision. So this is a very powerful tool for you to actually disapply national law, which is not in line with EU law. The principle of effective judicial protection, as I said, this is a general principle of EU law, which has a concrete expression in Article 19 and Article 47. And what the court has said is that the essence of the effective judicial review is designed to ensure compliance with the EU law. It's actually also the essence of the rule of law. So a member state must ensure that courts and tribunals within the meaning of EU law come within the judicial system in the fields covered by that law, meet the requirements of judicial protection. So the court has said, if we want this project, the EU law project, to be actually enforced and to be applied, you must actually have effective judicial protection of the rights guaranteed by the EU law. The principle of mutual trust means that actually other member states will trust actually that the common values in the EU will be applied in the same way across the European Union. We are trying actually to create an area without borders where the member state cannot check whether other member states are observing fundamental rights. That's why it's actually important for the court to abide to the rule of law values. The principle of sincere cooperation. As I said, there is a very strong emphasis here on the national courts in applying also EU law. So it's actually together with the Court of Justice that they fulfill this duty of ensuring that the interpretation of application of the treaties are observed. And the principle of primacy of EU law would mean that the EU law provisions, when there is a conflict, would prevail over national law, and even they would be even above law of constitutional order. So this is something that the court has been saying since 1964, Costa Ena case, and it's been actually again repeated in a recent Commission versus Poland case where the member state has argued that, yeah, the Constitutional Court has this view, so we will not apply primacy, but the court has said 1964, you have the case law is there and it's still valid. And I will just shortly go to my last slide.
In a couple of minutes, thank you. Yeah, last slide by all means, thank you.
Okay, just some practical tips how to approach cases before the Court of Justice. So the court has given a lot of consideration to the Commission's recent proposals under Article 7.1, so it would be worth mentioning if you have a case which would relate to this proposal. The court would also look to the Venice Commission opinions. And when examining the case, it would look into the context, the objective and combined factors. So it's very important to see what is the real effect of all these factors together. National law cannot make restrictions on Article 267, so a national law or case law cannot prevent a court from making a reference for a preliminary ruling. This was recently spelled out in the cases provided on the slide. And something for you to consider is that the request for a preliminary ruling must be admissible. So it must relate to a pending case. A non-admissible case would be where your question does not have any relation to the actual facts of the main action or its purpose, if the problem is hypothetical, if there is not factual legal material necessary to give a useful answer. So I will conclude here my presentation, and I'm happy to answer questions from the participants.